topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, South Florida. Welcome to another Ask the Expert show. We, for the last 16 years, have brought you the finest experts in the field of legal, health, financial, and home improvement. We have got a great show for the next 50 minutes. This is the first Thursday of the month, and that means Kay Bender-Rimbaum, our long-standing expert in the field of community association law. We also do a show in the Tampa market the last Tuesday of the month, same time. And we do a show in Orlando the last Thursday of the month, same time. And I got to just thank everybody. I know Robert Kay will also thank you, but you people send us the most incredible emails and texts. We really appreciate it. And in the future, just make sure you tell us whether you're an HOA or a condo. Let me introduce you to our expert today. This has been long running. Good afternoon, Robert.
Good afternoon, Steve. Hello, everybody. Happy March.
Yeah, I see you're in the office today.
No, I'm home today.
Oh, look like your office.
My home office.
Exactly. Well, listen, I am so glad to see you today. We have got so many questions, and you've got a couple busy months coming up with classes.
Yes, this is the time of year that things are pretty active.
Yes. So again, we see the numbers, how they go up every single month, which means we're getting new people every month. So tell people about Kay Bender-Rimbaum.
Okay, Kay Bender-Rimbaum is a law firm established in 1992 and continuously providing legal services to community associations in Florida for all this time. Condominiums, HOAs, all aspects of the legal needs on the day-to-day basis of associations, be it interpretation of restrictions in the governing documents, negotiating contracts with contractors, dealing with developer claims, dealing with collection of unpaid assessments, dealing with owner violations, anything that's the board's going to need from a legal perspective on a day-to-day basis is what the firm provides. We do so out of 4 offices currently in Pompano Beach, Palm Beach Gardens, you mentioned the Orlando area, and we have one in Tampa. So we're covering a large portion of the state these days, and we're available.
Robert, I got it. Just go ahead.
I said we're available online for Zooms from pretty much all locations anywhere in the state. And as you mentioned, we provide education, which is generally at no cost to the participants, which is always something that they appreciate.
Robert, I got to tell you, you and your partners have built up such an incredible firm. Basically, all you do is community association, and most of your practice is community association law. But what you've built is just incredible. And people out there, if you're listening for the first time, if you're looking for a firm to represent you, which you should have, K. Bender Rimbaum. And let's get to the questions. We got so many of them. We never get through all of them, but we're going to do our best we can.
Well, they're all good.
Start off. Yeah. Yes. No, but we really appreciate people sending their questions in. First one is going to be from Ron in Delray. He said, if you're selling your condo, what disclosures am I legally required to provide?
Well, this isn't a real estate show. This is a condo show, but that's a little outside the scope of what we do. There are requirements in real estate that you have to follow. There are disclosures of your governing documents. There's a form that most real estate brokers will include in the purchase contracts that outline all of those items. So it's really something that it should be pretty standard.
You know, you offer so many classes. I guess one you offer a lot of are your HOA certification classes you do for condos. Yes. Here's a email we got from Penny and Davey. She is a board member. She says all of her board watches your shows each month, and we really appreciate your seminars. And she said, I love the new HOA certification classes. I'm sure you're glad to hear that.
We do. Yes. In fact, we got one coming up on March 18th.
Okay. Is that HOA or condo?
HOA.
Okay.
The condo one will be on the 11th.
Nice. Okay. Jim in Pompano, which is your backyard, can we ask for too much as a board in regards to support animals?
Well, it's certainly conceivable that a board would ask for more than they're legally allowed to do if they're doing so without the assistance of their attorney. We always recommend in fair housing claim issues like this that the board do closely consult with the attorney before responding to any request for reasonable accommodation under the fair housing laws. It's a tricky area that you would think simple requests wouldn't be out of the question, but you can't be too intrusive. There's specific issues that you can look into, whether or not the issue involves a major life function of the requester and whether the accommodation is reasonable. And there are information that you would get from qualified medical providers, which don't necessarily mean just doctors. It could be the therapists or other similar medical providers. But the danger of asking for more information than you're legally entitled to can subject you to a claim of a fair housing violation that could result in a fine of over $10,000. So it's very important to involve your attorney in the initial stages of any such request. We do provide for our clients that wish a package that they can use for requests that contains forms to be filled out and instructions as to the limitations and the relevant information that they can go for. And that's something that they could consider looking into as well.
Okay. Here is Ray in West Palm Beach. He's an HOA. He wants to know about clubs. Do our clubs have to be authorized by the board?
Well, in your HOA setting, the clubs are likely going to be spelled out in the governing documents. That anything that's the governing documents provides for the HOA would fall under the HOA's purview. There can be clubs that are voluntary, that aren't open to everybody, but don't involve the participation of the association. That's something that's legally fine, but really would need more information as to what type of clubs we're talking about.
Okay. Lindsay and Boca Raton, another HOA, looks like they've hired a new management company who wants all the records. How long do we have to get records to the new management company?
Well, if it's your own management company that's handling your operation, I would think that you'd want to get the records to them as soon as possible so that they can get up and running and providing the services. In all likelihood, your contract with your management company should identify a time frame. There's nothing in the law that says an association has to give records to their management company in X amount of days. So that's likely going to be something in your contract.
Okay. Molly, a lot of Boca Raton today. We are an HOA. Hey, Robert, we're really training these people right now. They're letting us know if they're an HOA or condo. But we are an HOA. Yeah. We only have 2 board members, and we can't get a 3rd board member. How do we get anything done to our property? We have tried so hard to get a 3rd board member. We can't get trees trimmed or pressure wash.
Well, if the board consists of 3 seats and not 5 seats, then 2 is a quorum and you don't need a 3rd to function. If you have 5 seats, then you need at least 3 on there to function. So it really depends on whether or not this is a 3-member board or a 5-member board or more. Based on needing 3, I would think 5 would be the highest. The way it works in Florida is that if however many seats you have, if you have 5 seats, and then you're going to need at least 3 to make a quorum to have any business transacted. If there's 2 vacancies, you can still function when all 3 are there. The same in this instance, if there's 3 seats and there's 2 board members, they're a functional board. They can operate with 2. It's harder to break a tie, but hopefully they see things eye to eye on most of the issues. So I think that they should be okay unless there's more information they want to share.
Justin in Delray Beach, I heard your show last year when you talked about Kaufman language. It's been about a year. Would you mind explaining Kaufman language again?
Sure. Kaufman language comes about from a case decided by the Florida Appellate Courts, and one of the participants' name was Kaufman, so that's why their name lives on in infamy. The legal basis of that ruling is that in order for substantive changes in the legislation to affect an association as if it were part of their documents, the specific language of the Kaufman decision has to be included when they're subjected to the law. So the language you look for is that the condominium is subject to Chapter 718 of Florida statutes. The key language is as amended from time to time. Without that language, the law in effect on the date that the declaration was recorded is the law that applies, which can be confusing. And the reason for this is both the U.S. Constitution and the Florida Constitution contain a provision that says that the state cannot make a law that will impair an existing contract. So a substantive law is one that affects actual rights of the parties as opposed to a procedural one. And it's a very technical area of the law. It's considered procedural as how elections are handled. That's more of a procedural type of a law. But restrictions on what kind of vehicles you can have in your community is a substantive law. So if your documents do not contain the Kaufman expression, then the change in the law only applies to those communities that have the Kaufman language or are created after the statute came into effect. And that's the general overview of Kaufman.
Okay. I want to tell everybody, this is going to be a surprise to John and to Jeff. This show is so popular. It's always been at 5 o'clock Eastern time. We are going to replay this show tomorrow at 2 o'clock.
Hey,
just to get some new people in. So I hadn't even told Robert or Jeff this, but this show will be replaying tomorrow at 2 o'clock. So if you missed part of the show or you want to get some of your other board members, tomorrow at 2 o'clock Eastern. I thought I'd just let you know that during the show, Robert.
Sounds good.
Yep. So we're going to go to John in Boca Raton. He said, our term limits are in May. I'm a condo board member. How long can a person sit on the board?
Well, in 2018, legislation was included in the Condominium Act that says that an individual can serve for up to 8 consecutive years, and then can only continue after that if there's no one else qualified that puts their name in to run or with the vote of 2/3 of the membership. So the 8-year period started to run on July 1, 2018. So basically the term would be up at the election that comes up after July 1 of 2026. So if you're elected to a 9th year in May, then you're able to continue that service through the following election. But then you would fall under the restriction, even though you're in your 9th year, because it happened before the time frame of the statute. If that's clear.
Yes. Here's a Miami listener, Fred. And we get a lot of questions like this. They were flooded 3 years in a row. They're researching flood control. Will that require only the person on the first floor, or does everyone have to participate? Is this considered a repair?
Well, I'm not really sure what they're referring to as for the repairs that are at issue, but in general terms, it's one condominium and everybody has to pay a portion of the costs, regardless of whether they're affected by the issue. The same analysis would apply if you have a multi-level building that has an elevator and the elevator needs repair. The people on the first floor don't need an elevator, but they still have to pay their proportionate share of the cost of repairing the elevator. If it's to address a flooding issue, that would be a maintenance repair item, and that would not be considered a material alteration that requires a vote of the owners. And so I think that's what the issue that the question entails.
Yeah, we have a lot of people with multi-floors and only the first floor is affected. They all want to know if people in the second, third floor, if they are responsible also.
Unless there's something specific in the documents that shifts the cost responsibility, which can happen, but it's very unusual on something like that.
Robert in Boynton Beach wants to know, can you have too many claims where we could lose our association's insurance?
Well, it's certainly possible. Insurance is a very touchy area in Florida, and depending on the nature of the claims that are being put in, the underwriters evaluate every year as to whether or not they want to take the risk that the particular association may present to it. And if there's a large number of claims, then it is not beyond possibility that the carrier will decline to offer a renewal. Or they may increase the premium to the point where it's prohibitive to use them. Then you have to look elsewhere. But if you need to make a claim, you need to make a claim. You want to avoid the small ones that aren't much beyond your deductible or even under your deductible, so that you don't create a claim history. So be mindful of what your deductibles are before you make any claims.
This is our last question before we go to a break. Greg in Deerfield wants to know, I am a police officer and I take my car home. It's my second car. The board has told me I can't take up a parking space with my police car. Is that possible?
Did he say condo or HOA?
He did not.
Well, there is legislation that prohibits associations from blocking police cars from parking in the community. And if it's an otherwise valid parking of a second car, like there's no restriction on having a second car, the issue can't be that it's a police car. An association is not allowed to prohibit based on that.
Okay. We're going to, and I'm not forgetting about the schedule, but we're going to go to a break right now. When we come back, we're going to do the schedule, and we'll get to some of these questions in our chat line. Robert, how do people get a hold of your office?
You can reach us by email at info@kbrlegal.com. You can call the office at 800-974-0680, and that will get you to any of the 4 offices. Or you can go to our website, kbrlegal.com, and fill out the contact box on the main page, and that will result in somebody getting back with you within a day or so.
Very good. We're going to go to a break now. When we come back, first thing we'll get to is we're going to go over the schedule, and I'll get to a couple of the chat line questions. We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
Back. This is the Ask the Expert show. This is the first Thursday of the month. That means K. Bender Rembaum, Community Association Law. They do the most incredible customer service, and they offer greatest classes. Robert's going to go over the schedule for March, and we'll get back to your questions.
All right, well, coming up on March 11th at 9 a.m. to 1 p.m. on a Zoom webinar will be the condo board member certification with Campbell Property Management. And the course will be led by Danielle Brennan of our Palm Beach Gardens office and Andrew Black of our Pompano office. On March 17th from 8:30 a.m. to 10:30 a.m. For our listeners in the Tampa Bay area, there's a breakfast with a legal update of the 2026 legal update, which is changes from 2025. At the Sarasota Chamber of Commerce, There's 2 legal CEUs for CAMs, and the annual CEU for condo board members. Kirsten Hens of the Tampa office will lead that class. On March 18th from 5 p.m. to 8 p.m. on a Zoom will be the HOA board member certification, hosted by Campbell Property Management, and will be led by Emily Gannon from the Pompano office. March 20th, 10 a.m. to 11:15 a.m. on a Zoom webinar, we'll have another condo board member annual legal CEU, which will be led by Lisa McGill from our Pompano Beach office. On March 24th, from 11:30 a.m. to 1:30 p.m., Tampa Bay area would know there's a lunch with a legal update from the 2026 version. The 2025 changes to the statute at the Wright's Gourmet in Tampa. Again, there'll be 2 legal CEUs for CAMs for the annual CEU for condo board members. Kirsten Hens of the Tampa office will lead that one, and it's organized by the Castle Group. On March the 26th, from 11 a.m. to 12:15 p.m., another Zoom webinar, Covenant Enforceability for Community Associations, and Kirsten Hens will also be leading that. There's continuing education for CAMs and continuing education for HOA board members, and it's co-hosted by Copper Door Management. That's what we have for March. Now, I wanted to point out a couple of points in April. April 16th, there's a Broward Condo and HOA Expo. On April 21st, there's a Palm Beach County Condo and HOA Expo, and we'll be presenting 2 courses, guest restrictions and screening, and the 2026 legal update at each of these. And we'll have more information on that when we do the April show.
And these are also up on your website too, right?
Yes. Go to the website, kbrlegal.com, click on the calendar, and all of the upcoming events are identified there. You want to register yourself so you can get the Zoom information.
Exactly. So, Juan, let's see if we can get this question up from the chat line so Robert can see it. Our architectural ACB does the CAM's duties of deed restriction violating. They issue an extra courtesy violation notice. The ACB votes to send this notice without notice. Need notice for vote. I don't know if that's a question or not. It's as an HOA, by the way. I don't know if that's a question.
I can decipher the question, the Architecture Control Board is sending out notices of violation, and they do so without prior notice of a meeting at which they decide to do that. If that's the question, boards are supposed to, or committees of this nature are supposed to act the same as boards when it comes to noticing of their meeting at which a quorum will be in attendance and they're conducting association business and open to the membership to attend and participate. But that may be the only violation there, and unfortunately there is no division involvement for enforcement, so any kind of a claim of violation really would have to go to court, and it's unlikely that something like this is going to go very far in a lawsuit of that type when it's just about getting a notice of a violation.
Kara and Boynton, and we get this question a lot also. What is the authority of the Architecture Review Commission?
Well, that's going to be document specific. So you need to look in your declaration of covenants to see how the Architectural Control Board or committee has been structured, what authority has been granted to them, or if nothing is indicated, then you'd have to see if the board has minutes in which they have adopted a resolution that delegates powers and duties to the Architectural Control Committee. So there's nothing in the statutes that identify that. It's going to be document specific.
Okay. Here's Kathy in Fort Lauderdale. Many of our owners are aging out. Can the adult child serve on the board? These are condos that are handed down to the children. Do the children have any rights in the association?
Well, the qualification to serve on the board is generally spelled out in the Articles of Incorporation. And Chapter 617 of Florida statute, which also applies, the Not-for-Profit Corporate Act, indicates that unless the Articles of Incorporation require membership to serve on the board, then anyone can serve on the board who's over 18 years of age. So you have to look to the articles to see if that's been limited to members only. And if not, then children of owners would be allowed to serve on the board. Likewise, if there's any kind of documentation of an estate or trust that grants certain interest in the children, there may be some entitlement based on that contingent interest of a remainder after the death of the current owners. But it's unusual that would qualify them for service on the board unless the documents contain specific language to that effect. So that's something that you're going to want your attorney to investigate for you in your documents.
Bill in Palm Beach, our governing docs don't allow any video on the property. Are the new doorbell videos allowed?
I guess it would really depend on the specific language of the documents and how restrictive they are relative to the videos, because Ring cameras on the doorbell are very limited in their scope. They just show you who's at the door and they don't really go beyond that. So whether or not that would constitute a sufficient violation for an enforcement action is somewhat questionable. And it's not one that I would necessarily recommend the board spend money on.
Okay. Richard in Boynton, how far in advance do condo election notices need to go out, and what information needs to be on them?
Notices of what does it say?
Condo election notices.
Election. Okay. For the annual election, since 1992, the first notice of the election has to be sent not less than 60 days before the date of the election. In that notice should be specified documentation, which includes an invitation for all owners interested to submit their name into candidacy to run for the board. That gives them until 35 days, 35 days before the election to get their information into the association. And then the association has up into 14 days to get the second notice out, but it's generally advisable to do it in the longer term, especially when you've got people that are spread out around the country.
Kip in Coral Springs, if no one runs for the board, do you have to have an election? We are 121 units, and we are lucky if 20 people show up.
Oh, wait, I did misspeak on the last one. It's 40 days on their notice for your intent to run. The 35 days is if you want to include a written statement about yourself. So I just want to be clear on that. 40 days for your notice of intent to run. Back to 120 units and nobody wants to run.
Yeah, if no one runs for the board, do you have to have an election? We are 121 units, and we're lucky to get 20 people to show up.
Condo sounds more like an HOA.
Yes.
Well, it's different for condos and HOAs. So if this is an HOA and you don't, the quorum requirements for HOA is the lesser of what your documents say, or 30%. So 30% of 120 is more than 20. So if they only get 20, they don't have a quorum, so they can't have any meeting or an election. If the board's willing to stay on, then they roll over and serve another year. In a condominium, it's different in that everything's done through the mail. So it doesn't matter necessarily how many people show up, as long as you get 20% of the owners to cast a vote and you have enough candidates to have an election. I'm assuming this is an HOA question, though.
Right. Okay. Either Sony or Sonny in Miami Beach. If a condo year is from January to December, when is the budget supposed to be finished?
Well, the statute provides that the budget has to be set and finalized not less than 14 days before the end of the fiscal year or before the beginning of the new fiscal year. So if you're on a calendar basis, then by 14 days before the 1st of January, so around, what was that, the 18th?
Okay. This is an HOA dog rule, unenforced for 25 years. Realtor feedback indicates rule has been a deal breaker for prospective buyers. Board refuses to revise the rule. Any strategies for owners selling their home? Like we said, this is not a real estate show.
Well, the issue with an unenforced rule that's still on the books is it's still on the books, but how they go about it, they could republish the rule and grandfather in existing violations, and then the rule's back enforceable, but then they need to enforce. The fact that they haven't in 25 years is an indication they don't really intend to. But unfortunately, the only strategy for owners is to keep after the board to deal with it, or if that doesn't help them, then they need to replace the board with people of like mind. And they can do that either at the election or by recall.
You know, these people, these residents that have a problem with their board, you know, one of the things I've learned from doing this show for so long, if you have complaints, run for the board, make your voice heard. You know, we
Get involved. Absolutely. Go to board meetings.
Yeah, we hear about these people who can't get enough board members, but here we get questions of people with complaints about the board. Run for the board, right?
That's one answer, but you know that's a big commitment as well.
Here's Carl in Delray Beach. He said, "I love your show. Our staff watches every month. Can our annual meeting be done by Zoom?"
Yes, annual meetings can be done by Zoom, with the caveat that there still needs to be a physical location for people to go to and participate if they don't want to use the Zoom. So that might make it less enticing, but it is something that the statutes now provide for.
Okay. Craig in Boca Raton, what does it mean to ratify a decision of a board outside the meeting?
Well, decisions of the board are supposed to be made at meetings at which there's proper notice and an agenda that includes the item that's being dealt with. Another option for boards is by a written resolution that's signed by 100% of the board members, and then they can take action without having a meeting. But quite often during a month or however long there is between meetings, decisions have to be made. In such instances, yes, the board should make the decision because it's needed. And then at the next meeting, they ratify it, in which case a majority of the board members there in person or on the phone or however they do it, will vote to ratify or affirming the action that was previously taken. and that makes it official.
Okay. Get the board exit. Trying to read. Some of these are hard to read. Sorry, but sometimes the current board tries to ensure no one else can get on the board except their current buddies.
Well, that is a problem in many communities, and there's no good answers for that.
Okay. Let's go to, let's see, John and Delray. We are an HOA. Can we do voting certification like condos?
Well, for HOAs, your elections are supposed to be run in accordance with your bylaws. So if you want to adopt an election procedure, that is what the condominiums use, with the advance notice of 60 days and then the notice of intent to run by 40 days and the time frame for the second notice, you need to amend your bylaws to provide for that. So then you can follow that procedure. Many HOAs do it anyway, and as their management companies, or that's their mindset. And well, technically it's incorrect. It would take court, either a complaint to the division or some kind of formal court action to address it. And I don't know that anybody's all that inclined to do that.
Kenny in Pompano. I love your show. My staff loves your show. He said, I really respect what you say, and I can almost count on it as being gold. Can people running for the board send out bios?
Well, nothing precludes them from doing that in the law. If they want to spend their money and send communication out to the community about themselves when they're running, they can do that. The board likewise can send communication out as well. In the condominium, anyone who's running for the board has the entitlement to submit a bio that the association must send out in the second notice, as long as that's delivered by 35 days before and it's on one page, 8.5 by 11. Either way is legally acceptable.
Okay. Here's another question that we get a lot. This is from Cheryl in Fort Lauderdale. In an HOA, if I'm delinquent, can I still run for the board?
There is a provision in the HO statute that an individual delinquent is not qualified to run for the board at the point of nomination. So if you're delinquent on the day of the election and that's when that happens, technically you're not qualified to run.
Okay. Sybil in Deerfield, what is the quorum at an annual meeting for HOA? If we can't get a quorum, does the old board roll over?
Well, that was actually discussed a couple of minutes ago, that the statute provides for the lesser of 30% or whatever your documents provide. I've seen documents that say whoever shows up is a quorum, so they could have one person there and that would be a quorum, but that's not all that typical. Otherwise, 30% is the most that a quorum can be. And again, if you don't have enough to have a quorum and the board is willing to continue to serve, then they would roll over for another year or whatever the term is in the bylaws.
Okay. Josh in Miami, he's talking about a proxy. It seems if a proxy ballot for election, not a proxy for a quorum, it seems that this means that the owner's vote is not secret. Makes no sense. Your thoughts?
Well, the only time that owner's vote is required to be secret is in the condominium setting when they have the envelope and envelope. There is nothing in the law that compels in HOAs that it be by secret ballot. And a proxy, if it's allowed to be used for election, it would be a limited proxy where the owner identified, and it's been done that way in Florida for decades.
Kenny in Boynton, this is a condo. Can a condo owner ask questions at a general board meeting?
Every owner in attendance at board meetings and condominiums has a right to participate, which means asking questions on any agenda item. The board is allowed to adopt procedures that deals with how long you can speak and when during the meeting you can speak, but the opportunity has to be allowed.
Okay. Stephen in Boca, he said, we did a business renovation. We used to be a condo. We changed to HOA. Does a vote have to be made before the change in the carpet we changed? Is that a material change, or did we screw up?
Well, it really depends on what you did in your documents and whether or not the documents address material alterations to the common areas. In condominiums, the statute provides that there cannot be a change except as authorized in your documents, and a vote requirement of owners for certain changes that are material alterations, which could be changing carpet for tile or whatever type of flooring you change to that isn't carpet. In the HOA setting, it's going to be what your documents say. Now, many declarations of condominium do contain language that's similar to the statute, and if you use the same documents that you had before in your business change, then it might still be in there, but you need to check your declaration, however that's written, and see if there's any limitation on the board being able to do that.
Okay. Jerry and Davey wants to know if a material change was made 20 years ago without a vote, can a material change back to the original be done without a vote? In this case, from tile to carpet, back to tile.
Well, that's an interesting question that comes up periodically, and it's certainly been my opinion that correcting a mistake that was made by a prior board should not require a vote of the owners. But the chances of replacing the tile with the same thing that was there 20 years ago is probably low. So the recommendation we would make, and the likelihood that if a complaint was made to the division of condominium, they would find a vote was required, that a vote should be taken even though it wasn't done 20 years ago.
Okay. Stacy in Lake Worth, our HOA is still banning metal roofs. HOA attorney states the board has the right to define architectural standards, and that means flat concrete tiles only. Do you agree or disagree?
If the documents are written to give the board that authority to create those specifications or specifically provide for a limitation on the materials on the roof itself, then I agree. But and if it's just in the board, then it's possible that if enough owners can convince the board to adjust the specifications, then that should be something they could do. But it's certainly within the realm of legal possibility that what the attorney has indicated is correct.
You know, we do other HOA shows in other states, and I've got to tell you, I've actually had some of our experts say, I have to get back with you on that one. In the 12 or 13 years we have been doing the show together, you have never said that. So I really appreciate your knowledge, Robert. Tell people how they can reach K. Bender Rimbaum.
K. Bender Rimbaum can be reached at 1-800-974-0680 for any of our 4 offices in Pompano Beach, Palm Beach Gardens, Tampa, or our Orlando area. Or you can write us at info@kbrlegal.com, or you can go to our website at kbrlegal.com and fill out the contact box on the main screen, and that will get somebody to reach out to you.
Robert, sometimes I don't think I thank you enough for you and your staff. This is the easiest 50 minutes I could ever do.
Flies by.
We'll see you again next month, first Thursday of the month, 5 o'clock Eastern time. Stay well, my friend.
You as well. Bye-bye, everybody.
That's attorney Robert K. Bender Rimbaugh. That's going to do it for us today. We'll be back again with you next week with more Ask the Experts.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.